Hi everybody, welcome to my channel. Today we are going to discuss about the general principles of crime, and today it will be the principles of crime in Indian Penal Code, what constitutes a crime as opposed to what is liability in civil laws like torts or contracts, and what is a liability in crimes. What are the general principles that you must know? The first important thing with regard to crime is that there are various stages of crime. One is intention, preparation, attempt, and accomplishment. So the Indian Penal Code, not necessarily these things are covered in the Indian Penal Code, but generally you must know all these are the stages of the crime. One is intention, that is, you prepare in your mind that you have the intention to do a particular act which is unlawful. And next, it's the preparation. You make various preparations. For instance, if you plan murder of a particular person, then if you plan to stab him through knife, then you buy the knife. You make assessment of his schedule, where he goes, what he does, and how are you going to attack him. So all these factors would come into the preparation stage. And generally, preparation is not punishable except for certain offences like waging a war against a state. Next is the attempt and accomplishment. So these are the general stages of crime. Now, what are the main ingredients of the crime? One of the main ingredients of the crime is that it must be done by a human being, either a man or woman or whatever is the gender identity they have. We do not have, IPC do not punish animals other than humans. So if you're looking at punishing dogs, cats, or even cows, like what we have seen in ancient stories, scriptures, or how we see in popular culture, that does not happen. The primary accountability of IPC lies only with the human beings. Next, there must be a human action, and there must be an action which is based on particular circumstances that is prohibited by law. So what's important is that the circumstances must be prohibited by law. Of course, if the circumstances are not prohibited by law, then it wouldn't be considered a crime. Then what is the particular conduct in these circumstances? How does he carry himself in these circumstances, or the next important point? And the most important point here is a voluntary contact and foreseeability of the result. That is, he voluntarily did this particular action in order to harm a particular person, and he has a reasonable foreseeability in his mind that if I take a gun and shoot a particular person, he will die. So all these things are the main ingredients of the crime. Next, an important maxim, that is Actus Non-Facit Reum, Nisi Mens Rea. Actus Non-Facit Reum, Nisi Mens Rea. It means for a crime to happen, there must be a guilty mind plus act. There must be these both events. So even if any one is not there, then usually in our 90% of the cases, it would not be considered a crime. So the simple fact is that for a crime to happen, there must be an evil mind coupled with an action or omission that is prohibited by law. Next, what is the actus part? Now it refers to the action part. It refers to the physical element in the crime. It refers to everything that is not mental. It might be anything. It might be a commission of a certain time. It might be like taking a gun and shooting at a person, or it might be omission, ignoring a person by not taking care of whom you have the primary responsibility. For instance, if you have a baby, you have the primary care to take care of the baby, and if you willfully with the criminal mind, with the criminal intention, do not feed the baby or do not feed someone who is under your care, then it would be considered an actus. So actus is simply the physical, it is the physical element in the crime. I've already mentioned this, the conduct must be voluntary. So if it is forced or if it is out of threat, then it will not be considered criminal liability. Next, the most important thing is the defendant's action must directly cause the crime. The defendant's action must directly cause the crime, and this is another key rule, like you said, like you saw in the remoteness of damage concept. The most important thing in tort law is that the defendant's action must be directly responsible for the particular legal evidence. Here, similarly, the defendant's action must be directly responsible for the crime. Or versus Miller is an example of Actus Reus. That is, Mr. Miller lit a cigarette and then he slept, and he completely forgot what happened due to the cigarette being left lit. It got fire, and once he realized that there was a fire due to his action, he did not take any steps to put out the fire. He just simply went and slept in another room. So this is considered an omission, where he had a guilty action or a guilty omission. So the legal principle here is people who create dangerous situations or under a duty to stop danger. They are under duty to stop danger. This is where the examples of omission come into picture. Examples of omission come into picture. And the next important case is Orr versus Stone and Robinson. Here, people must protect others when they assume voluntary responsibility for their care. And this is another important concept where you put these examples in the omission part of Actus Reus. Next, coming to the most important thing, Mens Rea, as opposed to tort law where malice or guilty mind is not important. In criminal law, a guilty intention is a very important concept, and only for certain rare exceptions the concept of mens rea is done away with, like strict liability concepts and absolute liability concept. But in all other cases, you cannot pronounce a man guilty without having a guilty intention. Now let us see some of the differences between intention and motive. Now there is a key difference between intention and motive, and mind you, in criminal law, motive is not considered, but intention is considered. That is, motive is the basis for criminal liability, but intention is not. So that is the difference. Say for instance, if you want to kill a person, and the motive to kill the person is to take away his property, then here what matters is your intention and not the motive. So in criminal law, although guilty mind is a very important concept, What matters is guilty intention, and a guilty motive does not directly cause criminal liability, but it might aggravate the liability of a particular defendant. For instance, if he has a guilty motive and a guilty intention and a guilty action, if all these three is combined, then the severity of his punishments or the liability, criminal liability, can be much higher. Whereas if there is no guilty motive but there is only guilty intention, then in these conditions, then there is a possibility that the punishment might be reduced for the accused. In Prakash versus State of Vitranjal, motive of the crime is considered to be not necessary. Here, a house help killed family members where she worked gruesomely, and the police were not able to come up with a motive behind the crime. Despite this, the court clearly said that what matters is not a guilty motive. If the motive is not there, but if there is clinching evidence that there is the intention to murder these innocent family members, then it would amount to Mens Rea, that is guilty intention. So even without motive, a person can be found guilty. Now the difference between intention and knowledge, like I said, in the difference between intention and motive, clearly motive is not taken into picture, whereas the difference between intention and knowledge is again subtle, but there are two different concepts. Knowledge is the idea that if I fire a thatched roof, then there is a possibility that people living in those dwelling houses might get injured or might even die. That is the knowledge, but the intention is my idea in the mind to fire the thatched roof. So just like motive, knowledge can be of essence in criminal law. Sometimes knowledge might be taken into account, or sometimes knowledge is not taken into account, and again it is based on each case and the uniqueness of their circumstances. For instance, if you look at the patient-doctor relationship, where the patient has given his active informed consent for the doctor to perform a particular operation, and even though the doctor might have a fair bit of knowledge that it might harm the patient, he is doing the particular operation. So here the intention and knowledge portion differ. Even though he has the knowledge that it might harm the patient, but his intention is not the same, and here it might save the doctor. But in some other situations, knowledge coupled with the intentions, for instance, if you want to steal a particular valuable item, but you wanted to do that by way of destroying a property, and you have the knowledge that the method in which you want to destroy the property might result in human loss of life, then that would cause liability for you. And knowledge, there are two techniques of knowledge. One is actual knowledge and constructive knowledge, and in both the cases the criminal law liability exists. For knowledge, Shiraz versus D. Ritson case, in this case, a person was accused of providing liquor to constable on duty. He claimed the defense that there was no knowledge on his part that the constable was particularly on duty, and this was considered to be a mitigating circumstances, and the person who was accused of serving liquor was acquitted. Another concept is willful blindness concept. Willful blindness concept is a concept where you have some knowledge which might be suspicious, but you are not making enough further inquiries into that knowledge to get a proper conclusion. That is willful blindness concept. And in this case, a friend and his accomplice murdered a woman, and even though one of his friend knew that there might be a possibility that he might murder them. He did not make further sufficient inquiries like what a normal reasonable person would have done, and that is willful blindness. And willful blindness is similar to what I call as constructive knowledge, and willful blindness, mind you, is considered to create criminal liability. Now there are certain presumptions to mens rea, that is doctrine of mens rea is applied to all statutory crimes, and if a particular section is silent on mens rea, then it is presumed that mens rea is applicable. So it is always presumed that mens rea is applicable in all these situations except for few special occasions which I will tell later. So the presumption is mens rea is present in all the situations, especially when it comes to criminal liability. Whereas when it comes to IPC, the presence or absence of mens rea is indicated by certain words like knowingly, intentionally, or voluntarily. But even if these words are not given, the court have time and again interpreted these provisions and said that there is a presumption that mens rea will be present in criminal action, and until and unless there is an explicit or by necessary implication rules or mens rea. And this was given in State of Gujarat versus DP Pandey. State of Gujarat versus DP Pandey. There are certain exceptions to mens rea. One is it is a necessary element that is accepted by law, and when statute provides strict liability like Motor Vehicles Act, Arms Act, just like what you get in strict liability that came out of Rylance versus Fletcher in tort law, where even if you have reasonable foresight to prevent certain event, then by the very fact of doing a particular thing might bring in your absolute or strict liability. So in cases of strict liability, mens rea can be done away with, but if you are getting a question on where cases where mens rea has been excluded, you can it will be good if you can add these sections, that is 124A sedition, kidnapping, bigamy, sexual harassment, voyeurism, stalking, counterfeiting of coins. In all these cases, mens rea has been excluded by the legislature. But you must also keep in mind that there is a presumption that if a particular section is silent, there is a presumption that mens rea exists, and Supreme Court has time and again given this judgment. However, there are certain exceptions to mens rea, that is public nuisance cases, libel and contempt of court, public welfare, which is an economic welfare offence. All those things are where mens rea is completely exempted. Some of the key cases include Emperor versus Raghunath Roy. Here, even if the intention is criminal, then even good motive will not be considered. So here in this case, a Hindu stole a house from a Mohammedan, thinking with the aim that he wanted to prevent the cow from being slaughtered, but it was considered to be a theft. Whatever good motive it is, he was punished. Again, in State of Maharashtra versus M.S. George, here mens rea concept was taken. Mr. M.S. George was from France and he wanted to travel to India, and when he traveled to India, he was found with excessive amounts of gold that is in excess of RBI limit. So RBI in particular issued this notification when he was in flight, and he claimed that he was not aware of this particular notification, so there was no mens rea, and since there was no mens rea, he did not have a guilty mind. But court refused to accept this proposition, saying that they can be these are cases where the strict liability concept will apply, and mens rea, the doing away of mens rea is done in this case, which means even without mens rea you can be held criminally liable. And in Natulal versus State, it was completely different. Here the mens rea concept, doing away with mens rea concept was again taken into. Here there was a food grain owner who who asked for license from the government did not give the license, but they did not also communicate this refusal to give license to the particular person, and because he was not communicated, he was not known that a license was denied to him, hence he could not take any actions, but he continued to operate the food grains storage facility without governmental license. And when this case came up, and he simply said that there was no mens rea on his part because he was not aware of these things, here the court accepted his defense. Other cases where mens rea are excluded include strict liability in hazardous establishments. We all know the MC Mehta vs. Union of India case, where Reum fertilizers, the issue of helium gas leak, the decision came in the backdrop of the infamous UCC methyl isocyanide issue in Bhopal. Of course, strict liability doing of mens rea has also been given the Civil Liability for Nuclear Damages Act. This is again an act where even the operator of a nuclear power plant is bestowed with the liability of criminal action, even if he takes sufficient preventive measures. This is another concept of strict liability or doing away with mens rea. So generally, like I said, 90% of the time mens rea is essential, except for certain rare exclusions like public welfare, environmental legislations, or grievous crime which is of economic offences, then environmental offences, like in Indian Council of Environmental Legal Action. Even if there is no mens rea, polluters should pay the cost of removing pollution. That is, polluter pay principle was taken into picture. So usually there is mens rea, and this mens rea can only be done away when there is certain exceptions, like statutory exceptions, etc. With this, we conclude the topic on general elements or principles of crime. Tomorrow I will join you with another topic. Till then, thank you for joining. Do share this video, like my video, and subscribe to my channel.